found this offering from James Ho, who is a judge on the Fifth Circuit Court of Appeals, in a concurrence in a death penalty case out of Louisiana. Forget that issue. More, it's the philosophy elicited by his comments. Every level of the judiciary risks losing its credibility if judges fail to live up to the principles of impartiality. But appellate courts have at least one built-in check. No appellate judge can act alone. Appellate courts act only through multi-member panels, so appellate judges must convince their colleagues before they can exercise the judicial power of the United States. District court decisions, by contrast, are, with rare exception, made by just one judge. District judges are the only members of the judiciary who can exercise the judicial power of the United States without anyone's consent but their own. With unilateral power, there's unique danger that some district courts may get off track. So it's vital that district judges exercise their powers carefully and with integrity, and critical that appellate judges be ready to intervene when district courts refuse to stay in their lane. I think most people would say, if you didn't apply to a particular issue or particular parties, that that's pretty sensible judicial philosophy and review of the inferior courts with the Supreme Court as the ultimate backstop. The question is, how is this playing out in the real world across a range of policy issues? Is it consistent with what Judge Ho would hope we would see from the federal judiciary? For more on this and, of course, specific matters, we're pleased to be joined, as always, by Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of Manhattan, Southern District of New York, Manhattan, and contributing editor, National Review, also author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks for joining us. Appreciate it.
Morning. Good to be with you.
So before we get to the Abrego Garcia and the particulars of some of these issues, I mean, just what James Ho observed in that concurrence and what you think about not only what he said, but if what we're seeing is reflective of the concerns that he raised and how things should proceed as he suggested.
Well, I think Judge Ho is a great judge, and he ought to always be listened to when he opines, and he's certainly on the money with this. I happen to have written for the new print edition of National Review an essay on the problem with nationwide injunctions, so it's kind of along the lines of what he's talking about. Mm-hmm. But I would add to his concerns, I think, a cultural change in the law, at least as long as I've been a lawyer, which is now getting to be about 40 years. When I was a young lawyer, the district judges, the discipline was they wanted to get it right because they would be, it's not that they didn't have ideological bent any less then than they do now. You know, people are people. But the culture of the law at the time was that if the judge didn't get the decision right and it went up on appeal, it would be embarrassing to be reversed by the Court of Appeals. And I think the culture of the profession has changed in the ensuing years so that it's become much more partisan, and judges, especially progressive judges, care less about getting it right than they do about being perceived as being against all the right things. In particular, Trump, but not just Trump standing alone. So even if they know, they've become so partisan, I think, that even if they know they're going to be reversed because they're wrong, they figure they can always say they're being reversed because Trump hacked the Supreme Court or whatever dopey rationalization they make. But I do think the problem that Judge Ho talks about with respect to the unique power of district judges who do get to act alone is more dangerous now, more pernicious now than it was 40 years ago, because you don't have to worry so much about widespread power if the person wielding it is at least in good faith trying very hard to get the answer right, regardless of whether it is consistent or inconsistent with his ideological leanings. Now they want to do policy and they want to do politics rather than getting the law right. And I think that makes it more dangerous.
Right, and it seems to me that's accelerated in the Trump era, and as concerns were raised about lawfare, and people like me, like you, were saying, when the balance of power changes, don't say we didn't tell you so. You're incentivizing an eye for an eye that takes us down a very dangerous road, and perhaps we're starting down that road.
Yeah, well, that always was the danger. I think it takes a unique person to rise above it and say, look, I know they did it to me. It was horrific, but somebody has to stop. And we're going to now try to do actual law enforcement instead of lawfare. And I don't see that on the horizon. I wish it was there, but I don't see it.
Well, and now the problem becomes, I read some of what you had to say about Alito's dissent on the Supreme Court stay over the weekend. But the problem becomes when the Supreme Court, I would argue, is playing politics as well, discarding precedent to intervene where, as Alito argued, I thought persuasively, they had no jurisdiction.
Yeah, I think that, as I said in what I write, I think if you take it point by point, the things that Alito raised are all true. The problem is that one thing that he raised, he didn't really develop what the implications of it were. What he said was that in another case, the Trump administration had told the district court and given it an assurance that nobody would get deported in the next 2 days. And the problem, of course, was that Judge Alito had to look for another case where that happened because it didn't happen in the case that the court was there to decide. And I think that the reason everybody got spun up the way they did, and it's true that courts should never act if they don't have jurisdiction, is that a month ago, the administration wouldn't give straight answers to a court while it was deporting people. It now says it should have allowed to have habeas corpus petitions. And since all those pieces seem to be moving in the same direction yet again, and the administration again wasn't giving straight answers to what it told the ACLU was that it wouldn't deport the two named plaintiffs in the lawsuit, but it wouldn't make any assurances about the dozens of other people who had just been transferred to the Northern District of Texas. And the reason, obviously, they had gotten transferred to the Northern District of Texas is because the Trump-appointed judge in the Southern District of Texas had said, don't deport anybody. So they moved them across the district line, and they were about to deport them again. So I think the court technically shouldn't have acted. Why did they act? Because they're not getting straight answers. All the administration had to do was come in and say, look, we're not going to deport anyone until they have – we can argue about what notice is and what's required and what we need to advise these guys, but we're going to give them a reasonable opportunity, like the court ordered on April 7th, to file habeas petitions. If they had done that, I don't think the court would have intervened.
Well, is there with respect to the deportations, I mean, the arguments being made by, many laymen, which is a logical position. So we can open borders and let 10 million people in illegally, but in terms of removing them, we have to do it individually through this, through due process. And it strikes us as it strikes a lot of people as the lawless getting away with their lawlessness, while Trump and others are hamstrung by the bad faith acts that they conducted. But we were talking about this the other day and looking at some case law. Is there importance in terms of due process and being able to process more than one person at a time in this country illegally, to treat it as a civil removal action as opposed to a criminal proceeding? And this is a way for the Trump administration to move people where there's clear evidentiary support they're here illegally and they have no standing to be in this country? Yeah,
the things you raise are absolutely right. and that is an important distinction. Let me just back up and say, during the Biden years, with people throwing stuff at me, saying, look, there aren't the votes there. This isn't a time for doing greening and all this other stuff. I said that Biden should have been impeached over the border collapse and the non-enforcement of the immigration laws.
Yep.
And when they said we're going to impeach Mayorkas, I said that's stupid. Mayorkas isn't the problem. He's implementing Biden's policy. Biden's the one to impeach. And when people said they didn't have the votes, I said, I'm not an idiot. I know they don't have the votes. The point is, impeachment proceedings could do two things. One, he doesn't want to be impeached, so he might change policies because he cares what his legacy is. And the second is, it would be televised hearings that would rivet the country's attention to what was going on at the border. So they would have that good effect as well. But the main reason I thought Biden should be impeached was because I've been a lawyer and in law enforcement. I was in law enforcement for a very long time, and I understood that if you overload the system, if you overload the country, if you flood the country with illegal aliens, it's going to be very, very difficult to get them out because of the law, and also because Congress plays games with immigration enforcement. Those things like it passes very good statutes that say all these guys are supposed to be detained until their removal hearings are over. But when we have 20 million illegal aliens in the country, it funds 47,600 detention spaces, which is like, it's not enough to do the job, right? So this is a big problem. But you're right that the fact that it's civil and it's removal proceedings means that Congress can enact expedited procedures to get people out of here. We do have fairly expeditious procedures for removal when people are illegally in the country. What I think the problem is we've made it into a game where you come in and you say asylum, withholding of removal, and Convention Against Torture. Those are like the three magic words.
Yeah.
And then, then we end up having to litigate that. But you could easily pass a law tomorrow that says until we get the immigration down to X number, asylum's closed. Convention Against Torture. These are all discretionary acts of mercy by a government. There's no legal entitlement to be allowed to come into a country by asylum or with withdrawal of or withholding of removal protection or any of that stuff. So Congress could act in a way that could make this much easier to do. It would never be easy to do, but it would be easier than it is now.
All right. Well, let's talk about Kilmar Abrego Garcia. I mean, the Supreme Court, as you know, said the Trump administration has to facilitate his return. Right. What does that mean? And is he going to be returned to the United States?
So, Amy, I think yesterday there's a very important development in this. I'll have something up at National Review about this before. What facilitate means, I've argued from the beginning, is a function of what's our agreement with El Salvador. Mm-hmm. So if he was in the agreement with El Salvador, and that agreement gives us dominion and control over what happens to these prisoners in the end, then we should be able to just tell Salvador, give us the guy back so we can have proceedings in the United States along the lines of what the courts are talking about. But what seems to have developed yesterday is in answering interrogatories in that case, the Justice Department represented, it won't give the details of the deal between El Salvador and the United States, but it did say that it only applies to the Venezuelans who've been designated as alien enemies, meaning Abrego Garcia is not in that deal. If he's not part of that, then his deportation, even though it was illegal because he had this withholding of removal remedy from 2019, it's basically a deportation or a repatriation of a Salvadoran back to Salvador. And the other thing that's an important consideration is what the Supreme Court's order said was to facilitate his release from custody. Now, I think their assumption was release from custody so he could come back here and have immigration proceedings. But the fly in the ointment there is he in custody? When last we saw him with Senator Von Hollen, he was out and about on the street.
A nice jail, huh?
He was not in the jail.
Exactly.
So the thing is with him, he's not in the deal. He's not part of the deal that allows us to control the ultimate disposition, which means we've turned over Abrego Garcia to the Salvadoran government, and it's his presence there is under Salvadoran law. It's not under an agreement with the United States. So, look, the reality of the situation is facilitate could mean we ask Bukele to let us have him back. And, the reality is if Trump asked Bukele for that, Bukele, who is beholden to the United States because he wants more money for more prisoners, he would turn him over to us. Right. But the administration doesn't want to ask that because it wants to take the position that by asking us to have these negotiations, the judiciary is intruding on the foreign policy powers of the president. So we have like this niggling little reality where we know that if Trump asked Bukele would accommodate it, but it's that reality is taking place in this profound setting where what we're talking about is great matters of constitutional principle, like how much can the judiciary intrude on the president. And the circumstances are all caused by the fact that we sent the guy back and we shouldn't have.
And, I mean, what do you anticipate will ultimately happen with Trump's the power he's asserting under the Alien Enemies Act, so long as there's some due process afforded those that he intends to deport?
Yeah, I think that it would be wise. This isn't in Trump's nature, but the Alien Enemies Act really doesn't apply. And, we could go into the reasons why, but the point is he's going to have to litigate the underpinnings of the Alien Enemies Act. And he's not, so it's not just a matter of like due process. You have to prove the guy has some tie to Tren de Aragua. He'll also have to litigate the whole underpinnings of invoking the Alien Enemies Act. Judge Boasberg, who was much maligned in Washington when he still had the case, made a point that I still think is a very valid point and that the administration should take to heart. And that is, since they have already designated Tren de Aragua and MS-13 as terrorist organizations, you wouldn't have to litigate whether the State Department was right or wrong about that. They're not going to look behind the State Department saying these are terrorist organizations. So all you would have to do is show that they're members of Tren de Aragua or MS-13. And since you'd have to make that showing anyway, I think they would be better off going under the terrorism designation than the Alien Enemies Act. I just think it's cleaner in terms of getting them out quickly. But I think Trump doesn't want to admit that he shouldn't have gone the alien enemies route, so we're going to have that fight.
And is there anything additional that Congress should be doing here to more clearly define the president's power when it comes to immigration policy, and particularly with the exigent circumstances of trying to remove millions of people who shouldn't be here?
Congress has given the president lots of power. I mean, Trump obviously, I don't think, Dan, it's that Trump wants more power so much as it is that he wants to be able to expeditiously get these people out of here. The immigration laws give the president a lot of power, but you can't invoke wartime powers when it's not wartime. So if I were the president working with Congress, I would be working on the procedures for getting people out fast enough. And I would, in particular, since the big three problems are asylum, withholding of removal, and invoking the Convention Against Torture, I would limit the circumstances under which those could be invoked so that you could get people out of here quicker.
Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, contributing editor, National Review, author of the bestseller Ball of Collusion, the plot to rig an election and destroy a presidency. Andy, thank you as always. Appreciate it.
Have a great day, guys. Take care.
You too. And he joined us on our turnkey.pro answer line.
The more you listen, the more you'll know. This is Chicago's Morning Answer. Morning Answer on AM 560. The Answer. Hear sound teaching from God's Word from Dr. David Jeremiah on Turning Point. Each weekday morning at 9:30 on our sister station, AM 1160. Hope for your life.
Hi, I'm Michael Alfaro, host of The Michael Alfaro Show. Join me each week as we tackle the issues you want to know more about, like foreign and national policies, how big money influences Washington, D.C., and so much more. Learn firsthand from elected officials and political insiders about the important policy decisions changing our world. Find me at michaelalfaroshow.com and then join me, Michael Alfaro, every Saturday evening at 7, right here on AM 560, The Answer.
AM 560. The Answer.
You know, we were talking about Landman. Season 2 is not coming out until later this year or early 2026.
Yeah, you got to be patient with these things.
I don't like to be patient. All right, thanks to Justin Kosick and Quinn McCarthy. Couldn't do it without them. Today it's going to be raining on and off.